People say, what's it like being a contractor? And I tell them, you only have two risks.
What are some of the proactive steps that a contractor can take to mitigate that risk factor?
What are like the top three things that need to very clearly be laid out for contractors?
The very first question I usually ask contractors, do you want to be a contractor or do you want to be in the business of contracting?
There's like always something negatively associated with being an attorney. Why is that?
It's going to pay dividends on the backside.
Let's talk about state filing.
Contracts are your best tool to make sure you avoid problems down the path.
Eric, what's some of the wildest things people just miss that should be basic 101 in operating agreements?
Let me say the big picture is...
Welcome to Beers with Contractors.
Hey, contractors, tradies, it's Will. Listen, today's episode, super excited about it because we got Eric Daffern. He's an attorney here that specializes in construction law and contracts. We're going to go over a lot of details. I want to be very clear for this episode. This is not, for whatever reason, meant to be any type of legal advice. This is for entertainment purposes only. And if you want to learn more, reach out to Eric directly. That is the way, if you want that advice. Otherwise, this is for me and Terry to have a few beers, drinking with somebody in the industry, and just having a good time. So enjoy the show. Well, tradies, welcome to another episode of Beers with Contractors. Terry.
How you doing, Will?
I'm doing good. We still haven't got the keg back up and running. Sorry, that was kind of on my job. To those 4 listeners out there that, I'm sorry, we're up to 6 now, that know us, know that Terry and I got a kegerator here in our studio, and that thing was a block of ice 2 weeks ago, and I think it finally thawed out after 2 weeks, Terry. My neighbors below us probably aren't very happy about the dripping water, but, you know, what's more important here? You know, insurance claims or beer, right? So, but no, it is kind of funny, Terry, because we've never had anybody accidentally stumble into the studio during one of our sessions, have we?
No, I do believe it would be enjoyable just to see the reaction on their face when they walk into whatever this is.
Well, there was a contractor here today looking to fix a leak in the roof, and he kind of looked around like, what exactly do you do? And is that a kegerator? And the favorite, the crown jewel of our office out here is Terry with a good friend of ours. Somehow, did Jacob Steele give you that door for free?
Yes. So they had a damaged porta-john where it was a brand new porta-john. All the plastics were cracked except that front door, and we repurposed it and made it into a centerpiece of our podcast studio.
And it is the crown jewel. People get a kick out of our porta-john door, and people have started to take markers and write their name like so-and-so was here and put their little porta-john jokes on it. It's hysterical. Hey, speaking of the shit that a lot of contractors don't want to have to worry about in their life, I get so excited about these episodes because it seems like to a lot of us out there, we're grinding in our business, but then like we forget that there's an important part of our business around the legal aspect of our contracting businesses. So if you have not seen the episode with Martin Holland, he's a very good friend of mine. This gentleman was recommended to me by Martin. We've spoken a few times, and I'm just the wealth of knowledge he brings to the industry. Terry, I know you're in academia. Even you're going to learn something today.
Oh, that's not hard.
So let's get our notes out. But yeah, today we have Eric Daffern from Daffern Law. So Eric's got over 30 years of experience in practicing law. He brings kind of a unique perspective because everybody's got their specialty, but there are not enough attorneys around the construction field that knows the industry as well as he does. So much so that many of his family members are, well, they're clients of his, whether or not he chooses to have them as clients or not, but they bring another 30 plus years of experience. So, but yeah, I mean, he helps us as contractors do all the things we hate to deal with, like avoiding lawsuits, minimizing risk, and, you know, guiding you through arbitration and all of that. So Eric's practical legal insights, man, they are just razor sharp. So Eric, welcome to an episode of Beers with Contractors, sir.
Thank you. I appreciate being here.
Yeah. So, I mean, let's dive in because I know that your wife's a contractor, right?
She is. She owns a construction company, a GC company in Tulsa. It was formed in 1958, and she is the third generation to own it. And now my oldest son is running the company. So there's 4 generations.
Good to hear.
Now, I knew that about you, and I always like my first question to be like, how'd you get into this? And now I'm starting to think like, is this how you and your wife met? Was this like she had some legal problems and you could help with that in the construction business? Like, all joking aside, but yeah, like, how did you get into this specialty? It's so cool that you do it.
So, no, actually, I met my wife in college. I was a second year of law school, and she was getting ready to graduate college, and we met on a blind date and got married 35 years ago. It's been wonderful. I have two wonderful children, two wonderful grandchildren.
Good.
And it's been a great life. So, yeah, so that luckily she's not a client very often. We try to implement enough things in her company so she doesn't have to deal with a lot of the risk and some of the problems that you see out in the construction industry today. But how I got into this, I knew I wanted to go to law school. Well, let me back up even further. Back when I was in high school, our family split up and my father left the home and we ended up losing our house to foreclosure. And it was such a traumatic thing to me. I said, I'll never let that happen again. And so I became obsessed with trying to help people avoid those real estate and construction problems. And so I knew I wanted to go to law school to learn as much as I could about it. And as things worked out, I've been spending the last 37 years working with contractors and investors and homeowners and everyone in this industry to try to help them stay out of trouble.
So, Eric, with all your experience in the number of years that you've been working in this industry or defending contractors, right? What are some of the most common legal pitfalls that you see folks in the construction business getting into time and again?
So let me put it this way. People say, what's it like being a contractor? And I tell them, being a contractor, whether you're a general contractor or a subcontractor, specialty contractor, it's very simple. You only have two risks. And if you can manage those two risks, you're going to be successful in your industry. And that first risk is the risk of getting sued. If you can manage the risk of getting sued and stay out of court, and the risk of not getting paid. And if you can manage those two risks, then you're going to be so far ahead of the rest of the game that it's unbelievable. And so we spend a lot of time educating contractors and subcontractors how to manage those risks. And so education is a very big part of what we do. And one of the things that I think is important is just like a doctor. If you go to a doctor and let him take care of you early on, keep you healthy, keep you exercising, you're going to be much better. Instead of waiting until that disease comes, and then all of a sudden you're spending all the money, time, and effort just to try to get back to a healthy state. And so the same way with business, and I'm sure you guys have experienced this yourselves, if you can keep your company healthy and manage those risks up front, you're going to be so much better on the backside.
But I mean, you talk about managing these risks, right? And I know plenty of contractors out there who think they are doing the right things, but they're not. Like, what are some of the proactive steps that a contractor can take to really insulate themselves and try and mitigate that risk factor?
So I tell every contractor that you need to have a team approach. The very first question I usually ask contractors, do you want to be a contractor or do you want to be in the business of contracting? And there's a big difference. Do you want to be the guy with the pickup truck and a hammer, or do you want to be in the business of contracting? And whenever you're in the business of contracting, I always recommend 4 team members. You should always have a good accountant. You should always have a good banker. You should have a good accountant, banker, insurance agent, and a good lawyer. You need to get their cell numbers, get to know them, feel comfortable communicating with them, and have them help you as a team to mitigate those risks. That's the best way to do it.
Now, Will, I don't know, but it sounds like we just got introduced to 3 more guests that we should have on the show here in a little bit.
Well, we're just going to keep going the layers deep. Like after this one, Terry, I know we're going to bring on a divorce attorney. We're going to bring on a tax attorney for all of our evasion. But don't worry, everybody. We have receipts for the kegs that come into our office, just to be clear. But
business expense.
By the way, I love this because, Eric, I've had a chance to meeting people like you in the industry and a few others. Like, I think there's like this negative connotation that contractors have where it's like, oh, I don't need an attorney because I don't have a problem, right?
Yeah.
And there's like always something negatively associated with needing an attorney. And why is that? I mean, I don't get it. Is it because in the past, they've had served papers from an attorney office and they all of a sudden view all attorneys as big, bad, and aggressive? But are you seeing that with a lot of clients that come to you first?
Yeah, I think one of the biggest downsides of going to an attorney is just the cost. I mean, lawyers are expensive. And so if you can develop a relationship with a lawyer and spend a little bit of money up front, it's going to pay dividends on the backside. So I think the cost is a big issue. I think that in life, people have dealt with lawyers probably not under the best of circumstances, and that makes it very, very difficult a lot of times for people to understand what their role can be in helping you succeed.
Yeah. Well, and that's kind of the offset. It's funny, like I had a friend just this last week that I was talking to. He's like, yeah, I'm propping up another LLC. It's for a little side business I've got. So I'm just going to LegalZoom. And I'm like, dude, why are you going to LegalZoom? Like, I mean, it's just like templated operating agreement, state filing stuff. And it's like, dude, they're really like any attorney can do this for you and make sure it's, set up for your state.
Right.
And then you're not getting some weird random charge $500 every year because they set you up on auto bill. So, I mean, let's say we start at the beginning. Like, let's just start at filing. I can't wait to dive into contracts here in a little bit.
Okay.
We're going to spend a lot of time on contracts because Terry and I have yet to draft a contract with one another. We're going to do so today. But like, let's talk about state filing because I know a lot of people, and this involves the CPA too, is like, well, should I be an LLC? Should I be an S Corp? And C Corp, I say no, none of that. But I mean, what are you finding to be the norm and, kind of the standard operating procedure around that?
Yeah. So the first thing I'm going to say is I'm not an accountant. Okay. So I'm not giving you advice about the best setup. Every company is different.
Yep.
I can tell you that we see probably 80 to 90% of companies open up as a limited liability company, an LLC. And that's primarily because of the ease of setting one up. With a corporation, you have to have all kinds of filings. You have to prepare annual minutes. You have to do bylaws. You have to do all the different things. With a limited liability company, at least in Oklahoma, and I'm going to limit my conversation about Oklahoma because that's the only state that I'm licensed in. But you can file a limited liability company online very easily by simply filling out what's called articles of organization. And file your fee or pay your fee. And then the other document is an operating agreement. And I recommend everyone in the world that has an LLC to get an operating agreement because the operating agreement is really the agreement between the owners of the company that helps govern how they work with each other. So if something happens and you have to sell the company, you have a death in the company or a disability or anything that can happen, you need to have an operating agreement that's going to dictate how each of you are going to respond and what your rights and obligations are to your other partners.
Now, hold on, Eric. There's where we get into the fun stuff because I'll never forget a friend of mine. He said, I don't know why they call them operating agreements. They should call them operating disagreements because that's the only time anybody reads it. And unfortunately, in our businesses, a lot of times we share risk with partners and things like that. So, gosh, I want to know how much we can dive into actual Eric's client account scenarios. But Eric, some just around operating agreements, what's some of the wildest things people just miss that should be basic 101 in operating agreements?
Well, let me say the big picture is you should read every document in your business. Okay. One being the operating agreement. Now, some of the things that we see is when you have two partners and each of them have 50-50 ownership. Well, there you've created a potential stalemate if you can't agree on something. Okay. A lot of times we like to do a 51-49 split so that there's at least a tiebreaker or have someone come in to be able to do a tiebreaker. And so we see a lot of disputes between partners or members of the LLC because of that issue. And then we also see situations where if I'm in a partnership or an operating LLC with someone else, I'm in that LLC with that person. I may not want to be partners with that person's spouse. So if there's a death or a disability or your your partner can't work in the business, then we have what we call triggering events that will require you to sell that interest back to the LLC or to the other member. And the main purpose of that is just to avoid disputes. I mean, it's really just a pathway to get from point A to point B with the least resistance.
Mm-hmm.
Now, Will, I want to say something, and it's going to come off as an insult, and to be honest, that's how it's intended. But if you hear Eric talk, right, he is intentional in the wording that he uses. He is intelligent enough to make sure, like, I'm speaking from a position in the state of Oklahoma, and that is it, where me and you are just spouting off information. And I don't think we can underestimate how important having someone like a lawyer, like Eric, is, because me and you aren't thinking about any of this as we move forward in our lives, right?
Well, and it's funny, Sydney, you have your LLCs for your properties, right?
Mm-hmm.
And Sydney and I, we have a 51-49 split on our investment LLC.
Do I get to know which way?
You know which way. Because there was the first disagreement. It's like, well, like, she's going to be the tiebreaker on any decision in life. Why don't we just make it legal?
Yep.
Legally binding, right? Oh, man.
Well, and the other thing about the LLC, the reason that you want to have an LLC or a corporation or some organizational entity is that you want to have a corporate shield around you to help protect your personal assets.
Yes.
And so the whole purpose of setting these organizations up is primarily for creditor protection and to make sure that there's that corporate shield. Now, what that requires is for you to maintain corporate formalities. You should have your separate checking account. You should have your separate filings, have your operating agreement. Everything that will help separate you from that company is very, very important to set up in order to have that protective shield around you.
Mm-hmm. And you know what's so interesting, Eric, is that we all know contractors who will bust their rear ends to make that business successful, right? And they will work long hours and really do everything they can, but they won't protect it. And taking these steps really, one, saves themselves, saves their organization, but saves their family.
Mm-hmm. That's right. That's exactly
well, and I think this is probably a good flow of the conversation here, Terry. It's like we're talking about the startup and initial and being proactive in the business. So, and then maybe we'll get into, now we're getting customers, and now how do we reduce that risk that Eric was talking about? So let's say we're finally up and ready. We're about ready to start. We're going to start bringing on customers. What other final things should they concentrate on, Eric, from the legal perspective, to make sure that, hey, you are ready to start taking customers in exchange for goods and services?
So again, we get back to our team members. You want to make sure that your accountant has set up your books correctly. Make sure he's got everything lined up, and whatever method you use to keep track of your books, make sure that your accountant understands what you're doing and approves it. So you want to make sure you can keep track of all your expenses and all of your income. So that's one thing. Other thing is to make sure that you have adequate and appropriate insurance. Do you have general liability insurance? Do you have automobile insurance? Do you have workers' comp insurance? Do you have umbrella policy? You want to make sure that you have all of the insurance policies in place, and your insurance agent can help you analyze your specific business to make sure there's no gaps as far as insurance goes. So accounting, get your insurance in place. Work with your banker to make sure that you have adequate financing. I've seen so many companies get into trouble when they grow too fast and they don't have enough funds to produce that work, and they get upside down, and that causes all kinds of problems. Now, as far as lawyers go, you want to make sure the most important thing that you can do is have the appropriate contract. Contracts are your best tool to make sure that you avoid problems down the path. So, for example, depending on the hat that you're wearing, you may be a subcontractor. If you're a subcontractor, your contract is going to be different than if you're a GC. And so whatever hat you're wearing, you want to make sure that you get a contract that's appropriate for that place that you are in the chain of construction. And personally, whenever you see contracts 40 and 50 pages long, I love those contracts. And let me tell you why. Because if you have a 2-page contract, you're going to have so many ambiguities out there, and you're going to give some smart lawyer the opportunity to twist something, interpret it differently, and create an ambiguity. Now you find yourself in court. So I like those contracts that deal with all the different scenarios that you have and help get all the ambiguities out of the way. So I think having your contract in place is the most important thing you can do.
So, Eric, if you're looking at those contracts, right, what are some of the key areas or red flags that maybe a contractor should make sure that they have in place when moving forward with them? Or if they're signing a contract with someone, things that they should really watch out for because they have significant meaning?
Well, probably one of the biggest is, how are you going to get paid? Okay. So are you going to get paid on a percentage basis? Are you going to get paid on an hourly, time plus profit basis? How are you going to get paid? Another thing is, when will you get paid? One of the things we've seen more and more in contracts now between a GC and a subcontractor is that a general contractor will put in a pay if paid clause. And a pay if paid clause is nothing more than a clause that says, I, Mr. GC, do not have an obligation to pay you until I receive my money from the owner. So that means that if the owner doesn't pay the GC, you don't get paid. So depending on what interest you're trying to protect, you want to make sure that, obviously, if you're a subcontractor, you might want to keep that out. If you're a general contractor, you probably want that in, because a contract really is all about just shifting risk back and forth.
Yeah.
And so if you can shift the risk, then that puts you in a better position. So I think payment is a big one. You want to make sure who's responsible, scope of work, what's included in your scope of work, what items are excluded from your work. You just want to be very clear about all of the different things that go into the construction process. If something goes wrong, how do you document that? If you have a change order, how do you do a change order? Are you taking on what's called inferable work? What I mean by inferable work is, a lot of times plans aren't complete and you have to go and infer what you have to do to make it a complete working system. So it's very important to look at all the different elements of your contract to get rid of all of these ambiguities.
Well, and we do this at our company every year, Eric, and it's funny, we get out our contracts and we read them with our entire team. Because also it's like, well, and we have almost 80 employees, so it's like, hey, we should all know what's in here. And so, like, what are some of the top 3, you mentioned ambiguities before in contracts that just get either totally twisted up or should have been worded differently? Because I've heard all sorts of different things from attorneys, like the difference between negligence and gross negligence, the lien terms, things like that. But in your experience, what are like the top 3 things that need to very clearly be laid out for contractors?
Well, and again, it depends on what hat you're wearing. I mean, if you're a GC, well, you're going to have different things to protect than if you're a subcontractor. So really depends on where you are in the process. Again, payment's one of the big ones. Insurance requirements. You got to make sure that you maintain the insurance that is required under your contract. Another big one for subcontractors is usually in a GC contract. It says that you, the subcontractor, are taking on the same responsibilities that I have as general contractor to the owner. So what does that mean? It means that you need to go read the prime contract. You need to understand what obligations and duties you're taking on by agreeing to take on the same duties that the GC has to the owner. So now you've got 2 contracts to read. And a lot of people don't want to hear that, but I'm telling you, that is probably the best way that I can think of to help protect yourself.
Well, and with contracts, it's funny. I had a manager a few weeks ago, Eric, and changed my mindset if I'm completely wrong here. One of my managers brought a contract from a homeowner, and we're very home service based. We typically aren't subs. And the customer red inked all sorts of lines in our contract. He's like, what in the world is going on here? Like, what, this person's crazy. And I'm like, no, it's completely legal for them to red ink. We haven't accepted the terms of this contract. So let's see what they red inked, and let's see if we got a bolder red that we can follow up with. So, I mean, let's break that down real quick, because I mean, it appears to be fairly common in construction. Or am I just naive there, Eric?
Well, no, I think it's very important to negotiate the terms. And obviously, there's two ways to do it. You can redline everything and make the changes on the contract. One thing that I like to do is to do an addendum. You know, the GCs or the owners have spent a lot of money to get this contract the way they want. And a lot of times they're unhappy when you start marking out all their terms. So we prepare an addendum, usually a 2 or 3 page addendum that sets out the terms we want, that will go in and change the terms of the original contract. And then that way we can narrow down what we're going to talk about. And I can give them this 2 or 3 page addendum, and then we can sit down and have a conversation and negotiate back and forth to get a contract that's fair for both sides. That's really what you're trying to do.
Yeah.
You know, so Eric, I've been teaching for a number of years, and it wasn't that long ago I had a student come through, and he was taking classes, but he was working for himself, right? And small operator, and he had to go through and lien a customer, right? And it was his first time, and he's talking to me, and I'm kind of shooting from the hip and from my experience. Can you walk us through what that process is like, and what are some of the big ins and outs that they need to consider?
Sure. So the lien process, and one way that I explain this, is that it's a superpower that the legislature has given the construction industry to protect itself. I mean, how many other industries can you think of where if you're not paid for the work that you perform, you can put a lien on someone's house and ultimately sell the house to get paid? I mean, that's a huge, huge power that's available to contractors. But because it's a statutory framework, that means that you have to follow the statute very closely and make sure you do everything correct. Because if you miss a step, then your lien is invalid. And so let me go back for just a second. You know, all a mechanic lien is a way to secure your payment. It doesn't mean that you automatically win. You still have to go to court and prove your case that you're entitled to the money, but it just provides security to make sure that when you do win that case, that you have a source of funds to go collect your money. And the process is extremely simple in Oklahoma. I know there's several other states that have much more complicated systems. Texas is one of them. They've got a fairly complex system of doing liens, but in Oklahoma, it's very, very simple. If you're a general contractor, you have 4 months from the last day of work to put a lien on the property. And the last day of work is defined, the way I interpret it, as the last day of work on the original contract or any change order, because the change order simply is just a change of the original contract. It's not repair work or warranty work. Okay, that won't extend the time. So it's 4 months from the date of the last day of work if you have a contract directly with the owner. If you have a contract with someone other than the owner, then you're in the place of a subcontractor, and you have a few different rules. And if it's a commercial project, and I'm talking about generalities here, okay? So so there's some exceptions to all this, but if you're working on a commercial project or some other exceptions, you have to send a pre-lien notice within 75 days of the last day of work. Now, you have to send the pre-lien notice to the general contractor and to the owner of the property. Now, you have to be very specific about what you put in that lien or that pre-lien notice, because the statute says certain things has to go in it or it's not valid. And then after you send that pre-lien notice by mail, you don't have to file it, you just send it by certified mail is the way we do it. You have to file your mechanic lien within 90 days of the last day of work. And that's really it.
Are there instances where a contractor will be forced by an owner to sign away their ability to file a lien at the beginning of a project?
Yep. And that's one of another main reason that you want to read your contract, because sometimes owners will require that all lien rights are waived. And so in a contract between a contractor and a subcontractor, sometimes they put language in there that says that the subcontractor, in consideration of getting this job, the subcontractor waives his or her lien rights. And so you want to be careful and look out for that in the contract.
Yeah, I've seen that before, and it's like, whoa, time out. And it's like, well, if you want the job, you're going to need to sign this. And
Yep.
I'm like, all right, well, give it to somebody else.
That's right. Well, I tell everybody that every case has two aspects. It's got the legal side and it's got the economic side.
Mhm.
And sometimes the business decision is this just isn't the right job for us, because no job is better than a bad job.
Yeah. Well, and I want you to kind of expand on the business side a little bit, because it's funny. Have you seen, Eric, where we've got a really well laid out contract, but a handshake or a text message or an email has amended or undone the contract in some consideration?
Well, generally a conversation will not modify a written contract. Okay. Sometimes if you communicate through emails and it's clear that there is a change, then obviously you want to do a written change order. I mean, that's better, because usually that's what's required in the contract. It says that you're not going to do any work and they're not going to pay you for any work unless it's a written change order. So, some people may argue that, well, a writing will change a written contract. But again, you have to follow what the contract says, and it typically says that you have to follow a change order process. And if you don't do that, then there's no obligation to pay you. So I always say, go back to your contract, see what it says. And again, this is one of the reasons that you want a more complete contract, because it deals with all of those issues. And that way there's no question. And if you come in and say, or the owner comes in and says, I want you to do this for me. Well, give me a change order and we'll sign it and we'll get the work done for you. So you just need to follow the contract. In my opinion, that's the better process.
Mm-hmm. Yeah. And by the way, Terry, I know you're taking notes about a contract between you and I. I can see what you're typing on our little Google Doc here. And so now we're triggering Eric's billable hour. So Eric, if you bill us, be sure Mr. Terry Kleinfelter, because I can see your notes here, Terry. But no, this is perfect segue, Eric, because you do this for companies all the time, right? Proactive, right?
Right.
So we got our state filings, we're good to go. We got contracts, we're starting to get jobs, and then there's a freaking problem. And some of these can be quality related, but quality, I know, can be subjective depending on the terms of the contract and things like that. So, when we're talking now, it's often that we as contractors, we go to the business side where it's like, well, let's just do this because we don't want to get a bad review, right? And where, does that decision of we have a conflict with a customer, and let's work on the subcontractor side or the home services company. We're directly working with the homeowner.
Okay.
We've got a problem there, and so we're just going to go above and beyond now to help that customer. And then we get this satisfaction creep where we fix a problem, but now there's another problem. And it's like, oh, now there's another problem. So what should we be stopping and saying, stop this madness before we even get to that point?
Ladies, running your small business can be demanding. You got suppliers you got to work with. You're managing crews. Hell, you're chasing sales. It's a lot to take in. Listen, if you want to grow your business, you got to stop working in it and you got to start working on it. So that's where my friends at Foundation Rescue Supply come in. You're not just getting foundation repair products and waterproofing products and air quality control products. With their nationwide distribution, you're getting a partner who knows how to help you scale. And that's why I use them. The Foundation Rescue Supply team has industry knowledge that'll help make your life easier. You get the tools, the trainings, the systems that you need to move the needle. You want your sales team to close more leads? Done, because they have the proven process for that. You need your crews to work smarter, not harder? Done. Their installation training will get you out there and rocking and rolling in the field. With Foundation Rescue Supply, you're not just buying materials here. You're buying a better business system that they have helped create. And you sell more, you install more, and you grow your team. So the bottom line is this: you get best industry pricing, you get field productivity on track, and you get more revenue out of everybody on your team. So this is your chance to step up, scale up, and thrive. If you are ready to make that happen, head to foundationrescuesupply.com, check out their catalog, and speak to my friends, their team, how you can take beyond the products with your company with Foundation Rescue Supply.
Well, I think you're talking about two different things here. You're talking about legally, what should you do? And again, you document everything. conversations evaporate. And the old days, you could probably do a handshake. I recommend everybody do everything in writing now.
Yep.
And get clear about that. But then you also have the business side of it. And a lot of times you're going to have to make a business decision, whether it's the right thing for your company to step in and make some corrections, do some things that you probably may not feel that you have to do, but because of the business relationship, you want to make sure that this customer is happy. So it just depends on whether you're looking at it from a legal standpoint or a business standpoint. From a legal standpoint, whenever you take on a responsibility, even if it's not in writing, I think you're going to be held accountable for whatever you do. And so you just want to make sure that everything you do is documented appropriately.
Now, Eric, when I got into this relationship with Will, and there was agreements made, right, but nothing was in writing about who's paying for the beer and such, So say I didn't want to engage a lawyer because I'm cheap, right, which may or may not be true. And I go on and I use either like something offline, right, like LegalZoom, or I go in and use one of the AI systems to create something. What are are you seeing those being successful? Are you seeing them just putting contractors in a world of hurt? Like, what is happening in that arena?
Well, I think the biggest risk that you run is whether you use just something off the computer or the internet. Every business is different.
Mm-hmm.
Terry, what's different in your business is going to be different than in Will's business. And so the interests that you have to protect are going to be different than everyone else's. Now, you may have common interests as an industry professional, but every company is going to be different. And the problem with online internet contracts, documents, is they intentionally have to be general. They can't be specific to any one specific interest, or, they wouldn't be used. So I think that's another reason that you should develop that relationship with a lawyer to help craft those documents early on to make sure that it's custom to your business and to your needs and to how you like to do business. Everyone does business a little bit differently. And I think that if you can customize those documents, that's going to be better. Now, as far as AI goes, I think that's a new and exciting area that we're going to see. I know that some law firms are really starting to get into AI. I think it's a wonderful tool, and it would be great to see how this is going to develop. I'm not there yet. I'm not sure how it's going to develop. But certainly, I think there's potential for it to be of great use for business and for legal.
Yeah, and I'm guessing, Eric, have you seen kind of like some flimsy contracts or operating disagreements or things like that you're like, yeah, this looks like something that was written on AI?
Yeah, those are very, very easy to identify. Yeah.
And what are some of the signs that you can spot it real quick?
Well, it's just that they're very general and they're very ambiguous. And they don't get into very specifics. And in all fairness, I think a lot of those documents are good starting places. And if you feel comfortable with writing your own contracts, then those are great places to start, as long as you get in and customize it to what you need. I just think just getting a form off the internet, sure, it can work probably sometimes, but again, that makes me nervous when people do that.
Yeah. Well, and that kind of leads us into a few other things. And before we get into conflict with a customer, one thing that we see so much in the construction world is like insurance will just jump you into a lawsuit, like for various reasons, whether or not it's a vehicle issue or something like that. I mean, how can we protect ourselves from that? Like sometimes insurance companies are like, no, and we've already settled this. And we have no legal wherewithal to try to say, hey, wait a minute, like we have all of our documentation here. I mean, have you seen that? And how do we protect ourselves that way?
Well, you mean having an insurance company or insurance defense lawyer take over the case and settle it out when you don't think that you should?
Yes, exactly.
Well, I think that's the trade-off. If you're paying a premium for the insurance company to come in and defend you, every insurance company has two main duties. And the first duty is to investigate, evaluate, make an offer to pay if it's covered. but they also have the duty to defend you if it's a covered claim. And so I think the trade-off is if you expect them to come in and defend you and protect you, then they should have the right to come in and control that litigation. So I don't really have a problem with the insurance companies taking over if they're going to pay the claim and defend it. May not be the result that I prefer or want. But again, that's the purpose of insurance, and you pay in your policy premiums every year.
Yeah. I know we throw that out there a lot, Eric, where it's like, it's not a question of if you get sued, it's when, right? But I've been there. My wife and I have been there in our business, and I'm going to knock on wood because we have done just fine through all of our years and come out through it unscathed. But, you know, I think like the first thing a lot of contractors think is, oh, crap, we're going to court, right? Like, here we go. And by the way, I've been to small claims. That's, you know, not very intimidating for us, especially if it's lined out in the contract and we just go represent ourselves. But and something that's a little bit more of a conflict, you know, what do you see as the best or most helpful ways that construction and contractors have navigated that process that keeps us out of the courtroom, which is just racking up expenses for everybody?
Well, there's several things that you can do. I mean, one is that you can pick the type of litigation that you're going to go to. You can put in the contract that you're going to go to arbitration instead of litigation. And you can require in the contract that the parties will go mediate the case before any lawsuit's filed. And let me explain to you what mediation is.
I was going to say, hold on, for Terry, arbitration, litigation, mitigation.
Yeah,
I'm just kidding. It's not just for my friend Terry.
You're going to be mitigated here in a little bit. Well,
that's
trust me,
right.
buddy.
That's right, bro. Hey, that's funny.
So let me explain a little bit of what each of those are.
Yeah.
What I consider litigation is when you file a lawsuit at the county courthouse or at the federal courthouse, and you initiate a process in the courts. Okay, and then and the lawyers will then respond accordingly. And then you'll try the case before a judge, a public judge, whether it's a district, state court judge, or if it's a federal judge. Okay, so that's litigation. So then you have arbitration, which is nothing more than a private court. In other words, you hire a private person, usually a lawyer or a retired judge, to come in and serve as your judge. And that's done privately outside of court. So that's an alternative way to try a case. And then you have mediation, which is not litigation or arbitration. It's simply a way that the parties get together. It's when they get together with a third party who tries to facilitate a resolution. Okay. Now, litigation and arbitration, if you take those to the final conclusion, those are binding on the parties. So whatever is decided by the judge or by the arbitrator, you're bound by that. You don't have any choice. It's a binding ruling. Mediation is purely voluntary, and you can get up and walk out anytime you want to, but it's the best, in my opinion, and I'm a huge fan of mediation. Mediation is one of the best tools you can use to maintain control of the result, because once you turn your case over to a judge or arbitrator, you lose control of that result, and you have to accept whatever result they give you. So I'm a huge fan of mediation because it gives you that best chance to get the case resolved. But now the problem with mediation is it's a compromise. And you know what a compromise is, right?
Yep.
When both sides leave unhappy. Okay. So
great. I was not the definition I was expecting to hear, but that's perfect.
Yeah. So a good compromise is when both sides leave unhappy because one side pays more than what they think they should. The other side accepts less than what they think they should. But the case is over. You stop the attorney's fees and you control the results. To me, I think that's usually a good result.
Now, Eric, I've got a funny little story here, but I've got to ask this question first. We're not giving legal advice. We're just talking about what you do for a living and what you love to do.
That's correct.
Well, no. No, hold on. Like, do you prefer as a job, like if you did mediation or arbitration, do you have a bias towards each one for what you'd love to do every day?
You mean as a participant?
Yes.
Well, obviously, I'm a huge fan of mediation. I think that is, again, one of the best tools available to any contractor out there. Okay?
Well, and I want to give this case study, and that's why I was asking. Okay. So, Terry, have you ever been in either of these? Okay, so my first experience, I'm going to go way back. We're going to go back in time. I was a home inspector licensed at I was an associate in training home inspector at the age of 18. And we were brought into a mediation. And I grew up in a very small town in the mountains of North Carolina. So all the attorneys knew each other. And I was like, I had no clue what this was. I was like, okay, they're sitting on that side of the table and they're sitting on that side of the table. And then we were there to just be expert, testimonial to the case. And these lawyers screamed and yelled and tore each other apart because there's no judge to hold them in contempt of court. And I was like, is this what court is? I was so naive at 18. But like, there's some gloves that come off in this stuff. And is that what you have seen in the past, Eric? Like, I think they lived for that moment in mediation because there was no rules. Other than the arbiter or the guy mediating it. Sorry.
Yeah. Well, and luckily we've got a good bar here in Tulsa County, and the lawyers generally are very civil to each other, and we all get along, and so you don't see a whole lot of that. I mean, I guess there's times where tempers flare, but usually, at least in our jurisdiction, we have a lot of good mediators, and we've got a lot of good lawyers who work together and try to get things done. So it's very professional.
Well, as I aged, I got into, I was not involved in it, but I got a chance to sit in another scenario, and I was thinking, oh man, it's going to be like the UFC again. And then I get in there, and it was all calm, and I was like, well, that's disappointing. My first showing of this was like drag them out and knock them out type thing. It was just so funny. But no, in regards to that, I have found most people are intimidated by mediation. When it is, it's like it's just a facilitated conversation to bring resolution.
That's all it is.
And man, it speeds things up so much faster, especially when you're in the presence of some, call it authority, rather than on the porch of a homeowner's house trying to argue and garage sale back and forth resolution. So,
well, what I tell everybody is that a good mediator is an equal opportunity abuser. Because he's going to tell you what the bad things are of your case, and he's going to go to the other side and tell them the bad things of their case, trying to find common ground. Plus, it gives you an opportunity to help identify things you can agree on and identify what the true dispute is about. And so it really tightens the case up, regardless if you get it settled or not. And again, I just think it's a great tool.
Eric, it comes into mind that a contractor should look at legal agreements as a way to control a process more than just eliminate or completely prevent one from the onset, right?
Correct. So, I mean, again, in my opinion, the purpose of a contract is to reduce ambiguities, number one. Number two, identify everyone's obligations and duties to the other. And then number three is to create the processes to carry out the purpose of the contract, which is to construct or build something in particular. So I think that's very, very important, is to identify those processes of how things are going to flow through from performing the work, your scope of work, making application for payment, receiving payment, what your warranty obligations are going to be at the end. So no, it's the blueprint that I think that's so important that the parties use to get from point A, from the beginning of the project to the conclusion of the project. And it's the greatest tool, in my opinion, that you can use to make sure that those objectives are met.
Will, I always tell my students as they get into it that the contract is how the job is handled. It's how you view your relationship with all the parties involved. And then I challenge them to talk to their significant other about creating a contract for that relationship, and just let me know how that goes.
Well, I've got one, and she owns 51%. So Eric, but obviously you've been through different changes in the market, different code revisions, different changes in legislation. So let's look a little forward. From a legal perspective, what are some of the current trends you're seeing in construction and challenges specific to our state that, we should be preparing ourselves for or be aware of that may have not fully shaken out?
Well, I think especially in Oklahoma, you see a lot of construction through the tribes. They're doing a lot of construction and understanding how to navigate through that process, because the tribes are sovereign nations and they have their own rules and regulations that you have to follow. I think you're seeing more of public-private partnerships where you're using public funds and private funds to go in and construct a building, construct a project. And so you have to make sure that you follow those, they call them PPP agreements, public-private partnerships. Make sure that those are followed, because you're seeing more and more of those combination projects, I think. And then again, just making sure that I call it the food chain. You have the owner, GC, subcontractor, sub-tier subcontractor, suppliers, and make sure that everyone has a nice, even flow back and forth. And one of the biggest tools that we use for subcontractors is what we call a master subcontract. And that's when a general contractor will negotiate with a subcontractor one time. And they'll get in there and do the hard negotiating up front. And once they come to a final agreement, then that document controls all future construction projects that they do together. So in other words, you have a master subcontract, and then the subsequent projects usually are started through work orders that refer back and incorporate all the terms of that contract. So it's just, there's a lot of efficiencies out there that you're seeing in the contract world. And I think you're also seeing some other issues, some developments in insurance. I think different insurance products, E&O insurance and design insurance and other types of insurance are being developed out there. And you're seeing more and more insurance companies offer those products.
Now, Eric, when you see those master subcontracts, how long do they have a life for? And are they often renegotiated, 12 months down the road or 14 or what have you?
Yeah, especially, and sorry to add to Terry's question, because somebody had one for 3 years the other day, just a few weeks ago. And like with the volatility in the market for materials and labor, especially one of which was union labor related, that was one of those where it's like the window was pretty big and left them in a position where it could be pretty risky at some point. So thank you, Terry.
Yeah. So in our master subcontract agreements that we use, we say they last as long as the parties agree that they're going to last. Either party can cancel a master subcontract by giving written notice. And the reason that we do that is if it's a good working relationship and there's not a lot of changes in that industry, then one may last 2, 3, 4 years. But if you're in a very volatile one and you see something new develop, then you have the right to terminate. Now, that won't terminate the work orders that have already been issued. That would stop any further future work orders. Okay. So we typically will negotiate them about once a year. We'll go back and review, because what will happen is that you will run into a new issue that you never dealt with before. And we do this all the time. I mean, every fact scenario you can imagine pops up from time to time. Another one, for example, was after COVID, you had supply chain problems. And so you had prices just going everywhere. And so a lot of these GCs would come in and renegotiate their master subcontract, or the subcontractors would, to try to include escalation clauses. So if there was a big spike in cost, then they had a mechanism that the parties could share that increase in cost. So whenever you see a new development in your industry, that would be the ideal time to try to renegotiate the master subcontract.
Yep. That's so interesting, because I have a very fast cash cycle in my business. So it's like, heck, fixing 40 homes a week. But we have a lot of who was it? Zach from Stronghold Construction, Terry? Awesome outfit. They're doing a lot with the sovereign nations, man.
Yeah,
doing some cool work with the tribes. And I love my commercial GCs out there. I'm a little jealous at your average gross ticket, but I like my small ticket and predictable cash flow and conflict resolution. But nevertheless, it is so ironic that this last question will come to you, Eric, because it will allow us to stress test how well you read our preliminary podcast contract. Just kidding. You didn't have to sign anything. But we always ask our listeners, I am known in the industry as being one of the patron saint of screwing things up. If you're going to screw it up so bad, screw it up like a Texan. Do it so bad you can brag about it. What's maybe a mistake you made in your career, Eric, that you can at least look back, laugh about it, and maybe teach somebody out there about an opportunity that they can avoid?
But probably the biggest would be to think that a small contract, which my clients always want, they want a 1 or 2 page contract, and me agreeing to give them a 1 or 2 page contract, and then 6 months later they get sued because there's something left out of that contract. And I've just made that decision that if you want me to prepare a contract, I'm going to make sure that it's going to be one that will protect you, and that it's not going to open you up to problems down the road, because you're going to be very unhappy with me. You're going to be happy when I send you that small bill because I didn't spend much time, but you're going to be real unhappy when you get in the middle of this lawsuit that cost you thousands of dollars to try to get out of. And so I think that just having that concept of being very thorough in what you're doing is one of the best lessons I've ever learned.
Yeah.
And the other thing I'll tell you that I've learned is, after doing this for 37 years, one thing I've realized is that the owners, general contractors, subcontractors, and suppliers are all successful because they need each other. The subcontractor is successful because the GC is giving him the jobs. The GCs are successful because the subcontractors are doing their jobs. The owners are successful because the GCs and the subcontractors work together. And so if you go into a project with that attitude, I think you just have a much better result.
By the way, Eric, I know you've got good ethics and core values. I mean, when they want the 2-page contract, do you not just shrink it down to size 4 font and say, there you go?
The fine print on the back.
Yeah, the super fine print. Well, I got it to 2 pages for you.
He's using that 14-inch long legal document paper.
Listen, they get the margins down to nothing on the border, right? Let's go ahead and take our logo down just a little bit at the top. That's so funny. Well, Eric, I love these conversations because I always learn something when we have, insurance folks, accountants, and obviously attorneys on. And so how do people get a hold of you? Obviously, they can search Eric Daffern. We'll have it in the show notes, but I know you've been on tons of podcasts. You help people. You're involved in LinkedIn, things like that. So how do they get a hold of you if they want more information?
You can go to our website. It's daffernlawfirm.com. And we've got a lot of free information there. We've got some forms. We've got different things that you can utilize for very low cost. I encourage you to go there. I think one of the best things that you can do is to get involved in your local trade association. There's a lot of good trade associations here in Oklahoma. We do a lot of education for those associations. You can Google my name and it's got all my information on there. That's probably the best way.
Yeah. Well, Eric, I appreciate you. I know you are a pivotal part of keeping us in business out there as contractors. So I applaud you there. And thank you so much for that. Terry, I applaud you, sir. And I know that when we get done, we're going to turn the cameras off and you've already got a scribbled handwritten contract.
You're going to get served with papers here in about
Hold on.
a minute or two.
I got my red pens right here ready to go, sir. I'll meet you over by the beer fridge.
Yep.
And we'll start negotiating this out. By the way, Eric, can I, if I don't like what Terry gives me, can I say that I was under alcoholic duress in the event of this contract after the fact? Is that a thing?
It's probably not a good idea to be drinking during contract negotiations.
Oh, well.
There goes me and Will's.
Shit. Damn it. Well, that's our show, folks.
I know. We're done.
Anyway, we appreciate you guys. We'll see you next week in another episode of Beers with Contractors. Terry, I love you. Eric, appreciate you, sir.
Right,
and we'll see you guys next week.
All right.
And that's a wrap for today's episode of Beers with Contractors. We hope you enjoyed our chat as much as we did. Before we say our final goodbyes, a friendly reminder. Beers with Contractors encourages responsible drinking. If you choose to enjoy a beverage during our time together, please do so in moderation and only if you're of legal drinking age in your country or state. Furthermore, the advice and insights shared in this podcast are for informational purposes only. Always consult with professionals and experts in your field And be sure to follow local laws and regulations regarding licensing and permits. We're here to help, entertain, and inspire, but your safety and compliance are important. So, as you head out into the world of construction and contracting, remember to build responsibly and make decisions that stand the test of time. Thanks for joining us today. We'll catch you on the next episode of Beers with Contractors. Until then, cheers to your success.